Well, good morning and welcome to today's Advisors Forum, the Secure Act Revisited, an 18-month update, and how to plan for retirement plan assets in the post-COVID Biden tax plan era, presented by Elville & Associates Managing Principal and Lead Attorney Stephen Elville. My name is Jeff Stauffer, Community Relations Director with Elville & Associates, and I'll be moderating today's event. So how this will work today, if you're new to our webinars, if you are, welcome. We're glad you're here. You as the attendee are in listen-only mode. However, if and when you have questions, please note them in the questions panel on the right-hand portion of your screen, and we will take time throughout to address them. Your questions really help the presentation and add value. They help others learn. So please don't be shy in asking questions at any time. You received the presentation yesterday by email from me to take notes on it if you wish. If for some reason you did not receive the presentation, it is available in the section marked Handouts in the panel on your screen to download at this time. This presentation is geared towards our financial advisor community, but we do have some clients on it as well, so welcome to everyone. For CFPs, CPAs, and other professionals on today's webinar, you may receive 1.5 continuing education hours for attending. So per attendance records requirements, please email me your ID number. And for CFPs only, I also must have the last 4 digits of your social security number as soon as possible so I can submit your CE hours for approval. We're fortunate to have a number of advisors on the presentation today, as I mentioned, and we really appreciate you being here, as I know you receive a lot of different webinar invitations every single day. So as we believe very strongly in the planning team concept here at the firm, Steve will discuss more of this shortly. We are always actively looking to develop and strengthen relationships with our advisor community, and we always welcome the opportunity to meet over breakfast or lunch or at our office to learn more about each other, how we can help each other be successful, and how we can best serve clients. Also, our office is always available for your use for meetings as a resource. We have a lot of space here, and we welcome you at any time. On another note, everyone will also receive a post-webinar feedback email right after the presentation, and we ask that you please just take a couple minutes to fill out this survey to offer us your feedback about the presentation, and we always read every comment and value your feedback. We look forward to being a resource to you always, now and in the future. So I'd like to offer you just a brief overview about our firm and share a little bit about Steve. We have a lot to cover. So let me pull up my screen here briefly. And here we go. So, Elville & Associates, founded in 2010 in Columbia by Managing Principal and Lead Attorney Steve Elville. We have a number of different practice areas here at the firm, including estate and special needs planning, elder law and elder care planning, estate and trust administration, asset protection, guardianship, and tax planning. We have 7 attorneys, 12 staff members, and 5 locations. Our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and the use of superior legal technical knowledge. We do offer a lot of education here at the firm. We do that through our planning processes with our clients. We offer 100 educational workshops and webinars in the communities we serve each year, and also by way of our accredited client care program through the Client Care Academy in Boston. We're one of only 2 law firms in the state of Maryland and 60 in the country with that accreditation through the Client Care Academy. And we actually had our social event last night for our client care members, which we offer on an annual basis in the summer. It was a virtual wine tasting with a very exclusive winery in Middleburg, Virginia, and it was a big hit. Everyone really enjoyed themselves, and it was a fun time for all. So if you'd like to learn more about the CCP, as we call it, please reach out to me or Steve, and we'll be glad to share some more information about that with you. So Steve Elville, President, Managing Principal and Lead Attorney with Elville & Associates. His work as an attorney for the past 20 plus years has been centered in elder law, special needs planning, and estate planning with an emphasis in the areas of tax planning and asset protection. A member of a number of different national organizations, including the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys. He works to bring peace of mind to clients by creating solutions to the needs through counseling, client education, and the use of leading-edge legal technical knowledge. He is a seasoned speaker. Each year presents at about 75 webinars and workshops, conferences, and continuing education events. Also named to the Maryland Super Lawyers list for the 5th time in 2020, so congratulations to Steve. And he also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charitable organization he founded in 2014, and I'm privileged to be the executive director of. So if you have further questions about that, I'm always very happy to talk at length about the Elville Center and all the great work that we do in the communities that we serve. So that's a bit about Steve and our firm, and I'll go ahead and turn it over to Steve with a click of a button here. So Steve, I'll go ahead and turn that over to you.
All right, Jeff, thank you. And I'm going to, there's that button. Very good. And I should be in charge of the slides, Jeff, just a second. And it looks like I am. So thank you, Jeff.
Very good. Thank you.
Everyone. I appreciate that, Jeff. And happy Wednesday morning to everyone. It's a beautiful day. Welcome to this webinar, and to all of our advisor friends. Thank you, and our advisor colleagues, thank you for taking your valuable time this morning to share it with us. We're going to get right into the presentation here in just a minute. We have a lot to cover. For those folks on the webinar that are not advisors, for clients or potential clients, or for someone in the public who's just seeking more information, thank you for attending. And today I just want to add value, and we're looking for relationships with our financial advisor and CPA colleagues. As Jeff mentioned, we have a large facility here in Columbia, Maryland. We have an entertainment space. We have a very, very large board-sized conference room. If you ever want to use this or use the entertainment space for a client event or a co-sponsored event with Elville and Associates, we would very much like to do that with you. And if we haven't met you, if we haven't sat down for breakfast or lunch or coffee, we would like to do that with you. So we want to add value for our advisor colleagues. We want to help you to keep assets under management and build your practices and be a resource to you. So with that said, I just want to end by saying thank you to Jeff for all that he does to help me put on these workshops. Jeff is a very, very seasoned moderator. If you have any problems doing this presentation, please let Jeff know. And also let Jeff know if you have questions, and we'll stop occasionally during the presentation for your questions. All right, with that said, we have a lot to cover. I'm going to go rather quickly because there's so much to cover to give you in this update. And so bear with me, and anything that you don't catch in this particular session, we have about an hour and 15 minutes together before we go to questions. I want you to please feel free to contact me, contact Jeff with your questions. We will get you answers. This is a broad topic, and I guess many of you advisors have experienced the same thing we've experienced, that as time goes by since January 2020, and the public becomes more aware, of our clients become more aware of the ramifications of the Secure Act, their interest has been piqued, and many people want to make sure their planning is solid, that they know what their choices are with regard to the issues surrounding the Secure Act. So with that said, I'm going to get right into the presentation. And again, thank you for being here. So the Secure Act, Setting Every Community Up for Retirement Enhancement Act, specifically, was signed into law by President Trump in January of 2020. It's going to affect and does affect most estate plans, not all, but most. It ends the concept of the stretch IRA. I know many of you already are aware of this, so I will be redundant throughout this to drive home this information, so just bear with me. There are some exceptions to this ending of the stretch, but nearly all plans need to be reviewed. What we're going to learn today is, what does the Secure Act look like basically after 18 months or 20 months, however we want to measure it. We're going to review the fundamentals of planning for retirement plan assets and estate planning. We're going to talk about what is the optimal planning process, not just the planning itself, but the process of kind of thinking through the Secure Act. How does the Secure Act affect traditional planning methods for spouses? How does it affect planning for the shares of children? How does it affect planning for persons with disabilities or chronic illnesses? And what are the financial and tax and estate planning strategies available to clients to deal with the Secure Act? Now, we at Elville and Associates are not CPAs. We are not, although we do have some CPA attorneys here. Generally, we're not CPAs. We're certainly not financial advisors, but we want to speak to the financial aspects from our perspective as attorneys. We're also going to talk about the nuances, the special considerations, and examples. So this is a little bit of a marathon. So if you can just kind of bear with me, we will get to the end and we will get to the examples. And I want you to use this material as a tool for the coming months. So the IRS regulations are still not complete. There are many ambiguities that have not been resolved. Now, of course, we've been living through the COVID period. Lots of things have been on hold. IRS has been understaffed and on a shoestring throughout much of COVID. So we have many unanswered questions. The 5 and 10-year rules, how those apply, and I'm being very general because there are so many specific examples, it would not be possible to go into all particular examples, but the 5 and 10-year rules, meaning the 5-year default rule, which is the worst possible treatment under the Secure Act, all the IRA assets have to be withdrawn within no later than 5 years. And of course, the 10-year rule, which applies to most people because most people are not going to be exempt from the Secure Act, but there are still unanswered questions about the particular situations that can arise with timing. And one of those questions is people who die before 2020 or people who die and they die right before 2020 and the person they leave assets to dies right before the enactment in 2020. There are ambiguities about this. There are issues about what is the age of majority. So for example, certain states have certain rules about what is the age of majority, but the IRS code is very ambiguous with regard to the Secure Act. What is the age of majority? So why am I bringing that up? Well, remember that minor children are exempt from the Secure Act, but when they reach the age of majority, that's when they become totally, if they're healthy, neurotypical children, that's when they become subject to the rules of the Secure Act. And so the question is, when does that 10-year period start? Because they're going to be subject to the 10-year period. Does it start at 18 or does it start at another age? And the idea of the age of majority being something like 26 has been thrown out. But this is an ambiguous thing with the IRS code. People who are 10 years younger or less than 10 years younger or more than 10 years younger than the plan participant, there are different aspects of particular scenarios that can occur that can cause confusion with that, but those are very much of a minority situation. Multi-beneficiary trusts, where one beneficiary involved in that pot trust or multi-beneficiary trust is an eligible designated beneficiary. And for those of you who are not familiar with that, the eligible designated beneficiary is the new class of beneficiary that's very limited to 5 categories, which we're going to talk about. This is the person who is exempt from the Secure Act, but when they have a multi-beneficiary trust, what's going to be the treatment there? And there's going to be a lot of factors that the IRS has not yet considered. And the same situation where we have a multi-beneficiary trust, but all of the beneficiaries are eligible designated beneficiaries. So we won't focus on these unanswered questions today because we want to talk about a broader overview of what is happening with the Secure Act. But the important thing for you to know is that there are still many unanswered questions and ambiguities when we get right down to the specifics of a particular situation that could occur and certainly does occur in life, with regard to the timing of the death of a decedent who is a plan participant and the effect on the beneficiaries. So who is affected by the Secure Act for estate planning purposes? Well, persons whose estate planning for retirement plans is focused on the stretch out. And we know, for those of you who are on this webinar and you're experienced advisors or CPA, you know that that's been our focus. We are focused on stretching out the IRA, and that is going to be very much affected by the Secure Act. And then the second bullet point here, persons whose estate planning for retirement benefits involves beneficiary designating their plan, okay, their qualified plan or their IRA to a conduit trust. And we're going to get into the examples of what a conduit trust is. For those of you who are experienced, you know that a conduit trust is a trust that by its very nature must pass out all distributions from an IRA to the beneficiary. It cannot accumulate those IRA distributions. So we're going to look at a graphic example of that, and we're going to get into more of what a conduit trust is. Now, we talked about eligible designated beneficiaries. Who is exempt from the Secure Act? And again, I'm going to cover this a couple times, maybe even 3 times throughout the presentation. So if you don't get this, don't worry about it. We're going to cover it again. The surviving spouse of the plan participant is exempt. So that's the first thing we need to know. Minor children of the participant are exempt, and we just talked about that once they reach the age of majority, then they become subject to the 10-year rule, assuming that they are typical healthy children. Disabled persons, as defined in the code, are exempt. And I just want to take off a little bit on that. Special needs trusts are exempt for those disabled persons. Chronically ill persons are exempt, and a special needs trust, if drafted properly, is exempt for that chronically ill person. And persons less than 10 years younger than the plan participant, so this could be a sibling, this could be an older sibling. So people who are not more than 10 years younger, those people are exempt. Now, who is not really going to be affected? We talked about the different categories, and we're going to talk about those again, but who is really not affected? So persons who don't own an IRA or a qualified plan, they're really not going to be affected. And people who want to leave their retirement plans to charity. Okay, so those wonderful people who are doing that charitable work, they are not going to be affected. Now, there are 2 major threshold questions. Now, there's many questions, and in your own practices, if you're an advisor, you're going to have your own set of questions and your own process. But to me, as an attorney, there are 2 threshold questions if we just narrow it all down. One, we need to determine whether there's any changes that need to be made to the client's estate planning documents. So the documents themselves, do we need to make any changes with regard to the Secure Act? And number 2, we need to determine whether the client wants to do any kind of planning to minimize the impact of the Secure Act on their retirement plan assets, and the impact on the beneficiaries, and the impact on the estate plan, and the acceleration of income tax, and the loss of tax deferral, and the potential loss of asset protection. To me, these are the 2 threshold questions. Now, as we're going to see in the coming slides, there are many other considerations, but to me, these are the 2 threshold questions from an attorney's perspective. Now, as I mentioned, we have other important considerations, and so I'm just going to walk through them with you. And maybe you can use this as a checklist. We're not asking you to look at it from strictly an attorney's perspective, but as a financial advisor or CPA, we hope that this list is helpful. Who are the client's beneficiaries? So first of all, we really need to nail that down, because remember, charities, we're not going to be worried about it too much if the client is leaving everything directly to charity. But do they have what I would call healthy or neurotypical children, or do they have children whose capacity is in question, or they have special needs in the family? So how many beneficiaries are there? Okay. Should the retirement plans be directed to just one particular beneficiary? For example, if you look at the subcategory there of paragraph B, is there an eligible designated beneficiary among the beneficiaries? So if there's someone who is exempt from the Secure Act, should we be leaving all the assets directly to that person, and thereby maximizing the stretch out of the IRA assets and the deferral of tax, if we're talking about regular non-Roth plans? Are any of the beneficiaries charities? Are the retirement plans going to charities? And are the non-retirement plans going to individuals? So all of these fundamental things are really important considerations when we get right down to the complexity of the Secure Act. Now, so when we're talking about who should be the beneficiaries, now the next question in paragraph 2 here is, how should the beneficiary receive these assets? Should it be distributed outright and keep everything simple? There's a strong argument that says it should be. And if so, we want to make sure we understand very, very fundamental things. like beneficiary designation forms and making sure that's correct. We need to understand that most people are going to get a 10-year payout. And how do we deal with that for that particular person? Does that person have the right financial advice, and will they know how to deal with that? Now, the example here in simple outright distribution, why is this so important? Well, it avoids triggering non-designated beneficiary status. What we want to avoid certainly is a 5-year payout, or God forbid, no beneficiary designation, and the IRA fails and has to be distributed within 5 years, which during administration typically means it's going to be distributed immediately and all tax paid immediately. So by keeping it simple and having outright distribution, there's a strong argument that that guarantees the 10-year payout for the non-designated, for the non-eligible designated beneficiary, the regular beneficiary, so to speak, and it is going to guarantee that we're not going to get the 5-year rule. Now, of course, there are behavior and lifestyle considerations about whether or not we should keep assets in trust. So let's talk about that. So for those of you who have heard me talk before, you know we talk a lot about protecting people, protecting beneficiaries, whether they're spouses or children or others, in spendthrift trusts or further trusts. So when we have distribution to a trust, we're usually doing it for asset protection, creditor protection from general creditors and bankruptcy, divorcing spouses, and so forth. So that's all a given. There's no question we like to protect. And I know many of you would like to see your clients protected from the claims of creditors, or we're leaving assets in a further trust for special needs planning. And, you know, I want to get into this issue now of whether or not that's a good idea. Of course, with special needs planning, which we do a lot of, we are always going to need to protect the special needs or vulnerable beneficiary because of public benefits and other issues that are going on that we need to preserve. But when it comes to general creditor protection, should we really be using these trusts where there is not a clear need? So let's look at the disadvantages. Well, first of all, we have maintenance and upkeep of trusts. What do we know about trusts? The beneficiary has to know what they're dealing with if they're the trustee. If not, there has to be an independent trustee or third-party trustee. There has to be an income tax return every year for the trust, the 1041, and of course the taxation of trusts. So I know in many respects I'm preaching to the choir here of many very knowledgeable people who understand trust taxation, but it is a very complex subject. So just remember right now, in advance of President Biden's potential raising of income taxes to 39.6%, we're looking at 37% top income tax bracket at only $13,050 of trust income. Whereas if we didn't leave that IRA in a trust, now individuals would have to earn $523,000 to be in that set 37% bracket, or married filing jointly would have to earn $628,000. So very high income earners to reach that 37% bracket. So the question is, can we use trusts and minimize impact? And can we use trust where management understands how to deal with these things? So, you know, if we are leaving assets to a trust, we have to ask ourselves, what is the true cost? Okay. Now, bullet point number 4 talks about, well, should we draw down the retirement plan? And this is something that you and I would never have told someone to do in the past, but should we draw it down as a strategy? Or obviously convert to a Roth IRA during life. So can we avoid the destruction of the retirement plan by doing this? And is that a viable strategy? And then the 5th bullet point here is talking about, what about, you know, when we leave assets to a trust, what kind of situation are we leaving the trustee in? Because the trustee generally is not going to be knowledgeable enough to deal with an IRA that's left to a trust. So again, we're big proponents of asset protection. About 10 or 12 years ago, the Supreme Court said that basically if you leave an IRA to a trust or a qualified plan to a trust, let me repeat that again. The Supreme Court said that if you don't leave an IRA to a trust or a qualified plan to a trust, then leaving it outright to a beneficiary, there will be no asset protection. So naturally, as planners, we want to see the large IRA assets that people are accumulating today. We want to see those assets protected in trust. But when we do that, does the trustee really understand how to manage the trust? And is the cost overall of the income tax ramifications in light of the Secure Act, is that cost worth it? So these are really viable questions to really make sure that we're doing best practices, not only on the legal side, but in your world as well, in the tax planning side and the financial planning side. Now let's talk about the Secure Act and how it affects planning for spouses. Now I'm going to touch on this subject just a little bit, and then when we get towards the end of the presentation, I'm actually going to give you some examples. So traditional spousal planning, this will be no surprise to any of you, it really involves outright distribution. If I pass away, I leave everything to my spouse outright and free of trust just to keep everything simple, or do I distribute assets in further trust for a spouse? Why would I do that? Well, I want to provide either marital control. I want some control about how the assets are managed and how they flow down to my children or other beneficiaries, or I'm trying to protect against remarriage. So distribution in trust is usually for those reasons, but that's traditional spousal planning. I was talking to a young couple this morning who had done planning 5 or 6 years ago, and they were doing some planning kind of in a hurry, and everything was outright distribution. But now that they're accumulating assets and they have several children, we want to protect against remarriage. We want to protect and give the surviving spouse asset protection in the trust. So we're going to use a trust. So those are the traditional ideas about spousal planning. With regard to IRAs, the same idea, outright distribution or distribution into a trust. Now, the Secure Act considerations now as we think about planning for spouses are, should we use a conduit trust for a spouse? So let's assume we're not going to do outright distribution. Now, let's stop right there. If we do outright distribution, everything to the surviving spouse, we don't have any worries. The surviving spouse is exempt under the Secure Act and is an eligible designated beneficiary. They are not subject to the 10-year rule or the 5-year rule. But if we use a trust and we leave it to a trust for a spouse, that trust must be a conduit trust, which we're going to talk about in just a second, and that will still qualify as an eligible designated beneficiary. An accumulation trust, where we are accumulating the minimum distributions or all distributions coming out of an IRA, that will not qualify as an eligible designated beneficiary situation for a surviving spouse. We also have to think about the trustees. In my conversation this morning with a young couple that was very early, we talked about whether the surviving spouse should be the trustee of the trust or whether an independent trustee or co-trustee arrangement would be better for the trust for the surviving spouse. And that is all goal driven. So these are all Secure Act considerations, especially the first 2 bullet points here. And then, of course, we have some alternative concepts that we're going to give you this morning toward the end of the presentation. So this simple diagram, which I thank Jeff for putting together, talks about outright distribution. Very simple. And if you can imagine, right on top of that blue circle, imagine retirement plan assets, beneficiary-driven assets coming straight to the surviving spouse, no control, no further trust. Now, a marital trust, for those of you who are not familiar with this, is typically what we call a QTIP trust or a qualified terminal interest property trust. And basically it says that the surviving spouse must get all income, must get at least all income, but can also get income in principal, depending on what the person who is designing the plan would like to achieve. So here's an example of a will or a revocable trust leaving assets to a marital trust for the benefit of the surviving spouse. And on the left-hand side, if you can imagine an IRA or qualified plan coming to the marital trust, that can be driven straight into the marital trust and controlled by the deceased spouse. So that's the concept of a marital trust, almost an oversimplification, but I think a very good illustration. I'm just going to take a quick drink. Now, we've talked about outright distribution for spouses versus distribution into a further trust for spouses. And I used one example. There are others, but I used one example, which is a marital trust. Now I want to show the conduit trust, just for those of you who are not familiar with this. So for the last many, many years prior to the Secure Act, this was the planning choice or the planning method of choice for most people who are doing estate planning. And what you'll see here is the IRA is owned by the trust. The IRA is in that trust. But when the minimum distribution comes out, it's automatically distributed to the beneficiary. It comes into the trust and it must be distributed. So whether it's minimum distribution or any distribution from an IRA, when it comes into the trust, and this is a protective trust for the beneficiary, it must go straight out to the beneficiary. That is a conduit trust. Now, as opposed to a conduit trust, we have the accumulation trust. And this is the trust traditionally used for special needs or chronically ill beneficiaries. This is the trust where the IRA money comes into the trust, but it does not have to be distributed out to the beneficiary automatically, and instead it's accumulated. So Uncle Sam does not like this particular method. Uncle Sam prefers the conduit trust because he gets his taxes on a more timely basis. So here, traditionally, the accumulation trust was used again in special needs, but now we are recommending to many clients that they use the accumulation trust. This is assuming now that the client wants to leave assets in further trust for their child or other beneficiary who is not exempt. These are people who are not eligible designated beneficiaries. And by using an accumulation trust at the end of the 10-year period, at the end of the 10 years, if the IRA money has not been taken out of the trust, the accumulation trust traps the IRA money inside of the trust and keeps it from being 100% distributed to the beneficiary all at once. So most parents and plan participants want this method, this accumulation trust method. And for those of you who have clients who have not yet updated their trust planning or their will planning to make sure that there is accumulation trust provisions, this is something that most people are going to want to do, assuming that they are using further trust planning for their beneficiaries. It does guarantee higher taxes. It does guarantee that those assets are going to be subject to the 37% rate, which is why the decision about using trust has to be carefully thought about. And the idea of, well, do we do anything to try to mitigate or avoid the ramifications of the disaster that could occur with the large taxation of the assets? Do we do anything during life? Do we use a strategy, which we're going to talk about during the presentation here? Now, how does the Secure Act affect children and planning for the shares of children? Well, we talked about this just a minute ago. Healthy children can have outright distribution that guarantees the 10 years. No ifs, ands, and buts. It's very straightforward. Can't mess it up. Or we have distribution in trust. And if we have distribution in trust, we have those same issues. Do we use trust? Is it worth the cost? Is there a good reason for doing it? So all of those things, and we're going to talk about some examples at the end. Minor children, well, now we have some issues there because minor children are eligible designated beneficiaries. They are not subject to the ramifications of the Secure Act until they're 18 or whatever the IRS will consider eventually the age of majority. But however, when we leave assets in trust for minor beneficiaries, which we almost always would, okay, now we have a problem. If we use an accumulation trust, that will not be considered an eligible designated beneficiary for a minor child. It will not be. So we usually have to use a conduit trust, and that means that when distributions from an IRA come into the trust, it's going to go out to the minor child. So that's going to bring up issues regarding guardianship and so forth. But it's a commonly accepted practice these days that if we are planning for minor children, we are probably going to say, subject to each individual circumstance, we are probably going to say that it's okay for minor children to get some kind of distribution on the idea that the distributions will be small and that the natural guardians, the parents, would be able to use the funds very readily for the child for things that they need, and there would not be an accumulation of assets and a guardianship. So this presents a few problems that we're going to talk about in a little bit. All right, so I know I've gone on quite a bit in the first early going of this presentation. I'm going to stop very quickly to see if Jeff has fielded any questions from any person who's listening.
Thanks, Steve. Take a brief look here. It looks like we have one question, and that is regarding legacy trusts. And the question is a legacy trust a conduit trust?
Thank you for that question. The answer is, if you had your planning done in years prior to 2020, the chances are that the answer is yes on that. Now, not in every case. There are times when someone in the past, prior to the Secure Act, would say, I have a beneficiary that I want to provide for, I want to protect them, and I want to accumulate the minimum distributions inside the trust. But I would say probably 8 or 9 times out of 10, with planning prior to 2020, at least at our firm, it would be a conduit trust. And now would be a time to decide, do we want to keep it a conduit trust, or do we want to lock it down, so to speak, with a change that's fairly straightforward to make it an accumulation trust after the 10-year period? Excellent question.
Okay, I think that's all for now, Steve. Thank you.
Thank you very much. So we're going to continue because of the amount of information to share. What are the financial, tax, and estate planning strategies available to deal with the Secure Act? So we all know that if we keep and the prior question was a great example. If we have a trust, and let's just call it a spendthrift irrevocable trust. This is a trust at death, usually, for a beneficiary to protect them. And let's say we have that, and let's say we have the IRA or the retirement plan coming into that trust for the protection of the beneficiary, okay? And remember that if it's drafted as a conduit trust, which it probably is prior to 2020, with some exceptions, now what do we have? Well, we have a potential disaster, potentially, not always, but we have a situation where if the beneficiary does not take out the IRA funds, if they don't methodically take them out on a schedule, let's say 1/10 per year for 10 years or whatever the financial advisor would advise about this. Now, let's say they have a bunch of money in that trust, and after 10 years, 100% of the IRA money is going to be considered a minimum distribution. So that's why the person who just asked that question, my assumption is they are going to want to look at their planning, because they're going to want to determine whether they want to keep this conduit provision or change it to an accumulation trust where after the 10 years, all of the IRA money, if it was still in there, would not be forced out. Now, that's not to say there will be money in there after 10 years. And of course, at the 10-year mark, all of it's going to be taxed anyway if it hasn't been taxed already through distributions out to the beneficiary. But this is what is referred to as the conduit trust disaster. I'm not going to spend a lot of time on this chart, which you can see, which just illustrates that if we were using the required minimum distribution method, how little would actually come out of the trust versus the 10 years in this particular example. So what we don't want is for a beneficiary who's at risk to receive a lump sum distribution after 10 years if they haven't taken anything out in the 10 years, and then have a asset protection or creditor or spousal, bad spouse scenario occur where the money could be lost or put at risk. So what are the solutions? Okay, well, we want to defer taxes as much as possible. We want to manage brackets, and we could talk about this on an individual basis. And by the way, the focus of this whole presentation is to encourage advisors and attorneys to work together to really focus, which is hard to do. It's hard to do this on a team basis, but to really focus on planning solutions for clients that I'm finding increasingly clients want these solutions. They want some kind of a guideline about what should they do. And I think advisors and attorneys really should focus together and take the time, which is difficult to do, take the time to focus on formulating an approach. So we want to fulfill charitable goals if that's what the client is trying to achieve. We want to convert ordinary income to capital gain if we can, and we want to manage state income tax solutions. Now, here are some solutions that were brought out early on, and I think are still very viable solutions. And we're going to just talk about them in this order. Here are the tax income brackets, income tax brackets, I should say, just for your review, just so we can talk about, whether trust planning makes sense or any of these other options make sense. So to understand what I was talking about a few minutes ago when we talked about whether it made sense to leave assets in a trust or not, and is the cost associated with the income tax really worth it, we have to understand general tax concepts. And one of the very general concepts is that income is either going to be taxed to a trust or to the beneficiary. Now, I'm just going to make sure that we're talking about apples and apples here with everybody. What I'm talking about now is if assets from an IRA or qualified plan are left to a trust. If we're not going to leave assets to a trust like that, and it's just going to go straight to the beneficiary at outright distribution, then we're not going to be concerned about these slides that I'm going to show you right now. These slides, however, talk to the issue of parents and other clients who want to protect beneficiaries in trust. And now Uncle Sam doesn't care who pays the tax. Uncle Sam doesn't care whether the trust pays the tax or whether the beneficiary pays the tax. And obviously, in most cases, it would be better if the beneficiary paid the tax. So the concept of passing out trust income is something that we need to understand. And Jeff has graciously made this wonderful chart, this slide that really says if we have a trust, and this is a non-grantor trust, remember, for those of you who haven't thought about that for a while, a non-grantor trust is a trust where the trust pays its own taxes. And a grantor trust, such as a life insurance trust or a revocable trust, those are trusts where the grantor pays the taxes. But in this example, someone has died, and remember, for the trust to qualify for a see-through status for IRA purposes, it has to be an irrevocable trust. So this is an irrevocable trust that pays its own taxes. It's called a non-grantor trust. And now, once a year, when the income is measured by Form 1041, when the interest and dividends and income of the trust are measured, the trustee is going to decide to leave those assets in the trust to be taxed at trust tax rates, or they're going to pass out the distributable net income, or the DNI. Now, this is much more complicated than I'm making it sound, but as a concept, passing out the DNI to the beneficiary, and the beneficiary will claim that income on their own tax return. This is going to be true even for special needs beneficiaries, and that's a whole nother subject, and special needs parents are very concerned about that, but they don't need to be for various reasons. But this whole concept of distributable net income and passing income out to the beneficiary. Now, again, looking at tax rates for trusts, we're going to reach the highest tax rate at only $13,050 in 2021. So we don't want the trust to pay tax if we can avoid it, and we want to pass out the DNI to the beneficiary. So that's a concept we're just reiterating. Now, let's say that we had a multi-generational trust, and that trust is going to distribute out income to a lot of different people. Apologize, I thought I had another chart there, but what I want you to imagine is that we have a trust. It's a common trust for many people. It could be 10 or 20 people. And what the idea is to spray out the income of that trust to many, many different beneficiaries and get that income passed out. Remember the distributable net income, get that income passed out and get it on many, many different tax returns. That is a strategy to try to minimize taxes in the Secure Act world. So that's just something for you to be aware of. Roth conversions. Many of you are experts in Roth conversions and know how to crunch numbers and run analyses. This is what our clients are looking for. They are looking to spread the distribution over these other tax brackets, and if it makes sense, do Roth conversions so that when they die, their beneficiaries, especially if they're leaving assets in further trust, but even if they're not, but especially if they're leaving assets in trust, to convert those traditional IRAs to Roth if they can, and therefore kind of beat the system, so to speak, assuming they have enough time to live after they've made the Roth conversion so that they can recover from it. And many of you are experts in that area. Now, we've always thought, as we continue to move on, we've always thought it was best to leave 100% of the IRA to the surviving spouse. It just needs to be thought about. Should we leave some of the IRA to surviving children and not 100% of it to the surviving spouse? Surviving spouse may not be too happy about that, so we have to be careful. But the idea is, what do we do to maximize how long children or other beneficiaries who are not eligible designated beneficiaries, how long do they have to stretch it out? And is it a good practice to not leave 100% to surviving spouse, which most of the time we would do? Charitable remainder trusts are a big alternative, but they don't do 100% of what we would hope they would do, which is simulate a lifetime payout to the beneficiaries. So remember that prior to the Secure Act, beneficiaries had the right to stretch out the IRA assets for their lifetime, defer taxes well into their 80s. And so that's now been eliminated, except for the eligible designated beneficiary statuses, which are about 5 categories. Charitable remainder trusts, remember, are designed to have lifetime beneficiaries. You contribute, let's say, low basis assets to a charitable remainder trust. Those assets can be sold within the trust. And in this example, we're leaving a qualified plan or an IRA to a charitable remainder trust, and it's going to distribute income to the grantor or the grantor and the grantor spouse and children, and it can simulate up to 20 years of payments or for lifetime, depending on what the math says. Sometimes the beneficiaries are so young for purposes of children that the lifetime payout won't make any sense, but it could simulate a payout. The problem is the payout is not going to be quite as good most of the time as what could have been achieved prior to the Secure Act. And the other problem is, of course, which is not necessarily a problem, but it's just a fact, that the grantor has to have some charitable intent. So for certain people, using a charitable remainder trust to simulate close to what could have been a lifetime payout under the non-Secure Act world could be an alternative, as long as that person is charitable minded. So we need to give people illustrations about these kinds of plans so that they can make intelligent decisions. And of course, state income tax planning. So theoretically, where there's a state that has no state income tax, you could leave IRA assets to a trust in that state. And depending on state law and some other factors, it's possible that you could avoid state income tax on the IRA assets. Now, life insurance, along with Roth conversions, is a huge strategy. And many of you are experts in life insurance and life insurance strategies. And I'm just going to say this gets me kind of excited. And I like working on cases where we can show the client strategies that have to do with using life insurance to hedge and to relocate IRA assets so that we can try to create more wealth transfer despite what may happen with the Secure Act. So life insurance is a huge strategy. I would strongly recommend that all advisors, including attorneys, work together to try to present clients with illustrations that they can actually understand. I believe that clients would purchase more life insurance and engage in more life insurance strategies if they could really see the numbers and understand that we're taking money from this pot, let's say, hopefully in that situation, taking it from the IRA assets and moving it into insurance, and thereby leveraging and increasing the overall wealth that's transferring. That's what it's all about. And I'm hoping that we can continue to do more of that as the years go by under the Secure Act. All right, Jeff, I'm looking at my time. I think that we're really doing well. We may finish a little bit early, have some categories of examples to go through here. Any questions at this point, Jeff? I know I'm going through a lot of dense material very quickly.
Thanks, Steve. No further questions at this time. Of course,
Very
we
good.
always encourage questions. I know there are some questions out there. Please don't be shy in posing them. They always help others learn. So other people have the same questions you have. So please go ahead and pose them and we'll get them to Steve.
Thank you very much, Jeff. All right, as we go into, I guess, what I would call the last section of our presentation, let's just get back to the basics now. Under the old rules, we had 3 categories of beneficiaries, 3 categories of IRA beneficiaries, so to speak. Non-designated beneficiaries, which were subject to the 5-year rule, this would be an estate, or it would be a trust that does not qualify. It would be a trust that doesn't qualify for various reasons that disqualify it as a see-through trust. Designated beneficiary status, this was the person, like we've been talking about, who could stretch out the IRA for their lifetime. And surviving spouse beneficiaries were exempt from these kinds of onerous rules. So we had basically 3 categories of beneficiaries. Now under the new rules, we have a 10-year payout. And for those of you who are not familiar with this, there are no annual payouts required and no required minimum distributions under this 10-year rule. And this is going to apply to most beneficiaries, okay? And we have 5 exceptions, which we're going to go over again in the next slide or two. But we have the new categories. So the new categories of beneficiaries to replace the old are, we still have the non-designated beneficiary. This is the estate that's going to cause the 5-year rule if the IRA goes to an estate. It's going to be someone who does not qualify because somehow in the planning process, the beneficiary designation failed or the trust failed, and it's going to get the 5-year treatment. We have the designated beneficiary, which is going to receive the 10-year treatment. This is going to be the vast majority of people. And then we have the eligible designated beneficiary, and we're going to cover those categories again. So 3 new categories: non-designated beneficiary, designated beneficiary, and the new class, the eligible designated beneficiary. Now, eligible designated beneficiaries, again, are surviving spouses, minor children until the age of majority, disabled persons as identified by the code, chronically ill persons as identified by the code, and persons that are less than 10 years younger, okay? But in the Conduit and Accumulation Trust rules, there really hasn't been any change, okay? And it's important to know that there are a few nuances. So if you're a busy person and you think, well, gosh, there's the 10-year thing and I understand this, well, that's generally true for 95% of what we're dealing with. But just know that there is a possibility that depending on when a person died, depending on how early in a year that they die, it is possible to have a payout period of longer than 10 years. It's possible to have an 11-year payout period depending on when that person died. And of course, people who died before 2019 or prior to 2020, I should say, those individuals, there are scenarios of timing when there's certain deaths occur where there is confusion about the treatment of the beneficiary and how long they have to stretch out the IRA assets. So just know there are some nuances and ambiguities. Now we've gotten to the questions. I'm going to slow down here a little bit because we're ahead of schedule. And I wanted to get through that. I wanted to make sure that we weren't going to run behind. Let's start with planning scenarios for a surviving spouse. So we talked about outright distribution, and remember, there's nothing wrong with this. The surviving spouse has certain benefits. They can roll over the IRA to their own name. This qualifies as an eligible designated beneficiary for the surviving spouse. Now, if the deceased spouse leaves assets, remember I'm talking about that example now where the arrow is pointing to a trust. If that person leaves an IRA asset to a Conduit trust, the Conduit trust says what? When minimum distributions come into the trust or distributions come into the trust, they must immediately be distributed out to the beneficiary. That qualifies for eligible designated beneficiary status. And Uncle Sam is very happy because they get to tax the distribution. Now, there can be a combination of Conduit trust and Q-tip trust or marital trust. Now, remember the marital trust says at least income must be distributed to the spouse. The Conduit trust says the greater of income or the minimum distribution has to be distributed to the spouse. As long as that conduit element is there, that will qualify as an eligible designated beneficiary. So we're talking trusts here for the surviving spouse. An accumulation trust for the surviving spouse will not qualify as an eligible designated beneficiary. So if we're using a trust for a surviving spouse, we probably don't want it to be an accumulation trust, even though an argument could be made, well, I want that money to be accumulated and controlled so that it definitely goes down to my children or other beneficiaries at my surviving spouse's death. But what we're going to have a problem with there is taxation, as we talked about earlier. And a QTIP trust, or a qualified terminal interest property trust, that is distributing out only income and so forth, we're going to have taxation issues there as well. So clients need to be thoughtful about this. And I think best practices is really to understand that many people are going to want these trusts, but they're going to need to understand the downside. Okay. Now, second and third marriages, the spouse who dies is definitely going to want control. They're going to want to think through how they do that. Okay. The problem is that the QTIP trust or the Conduit trust is not as rosy as it looks. What is the motivation of that spouse who has been married the second or third time and wants those assets to go down to their children or other beneficiaries? What is their motivation? They want to make sure that the surviving spouse can't completely deplete that trust and the IRA. The problem with the Conduit trust is that if the surviving spouse lives long enough, he or she will deplete that Conduit trust or combination Conduit and QTIP trust. So that's the problem, and a spouse that plans that way needs to know that their intentions could be defeated if the surviving spouse lives long enough, and that may be okay. That may be a risk that's worth taking. The QTIP trust may be a risk that they're worth taking, that they feel is worth taking because of the taxation issues, but there may be alternatives, and one of those alternatives may be to leave assets to both the surviving spouse outright and the children outright. As we mentioned a few slides ago, maybe that's a strategy not only to maximize the periods of time that the children who are healthy and well, that they can stretch out the IRA assets, but it also may be a strategy to satisfy the concern of not having to deal with the taxation issues and also making sure the children get the assets as well. And of course, life insurance is a powerful tool here too. So I know that in our practice, we certainly don't see enough proposals for life insurance. I want to encourage advisors and CPAs on this call, please talk to your clients about life insurance strategies. We believe that life insurance is a powerful tool in these kinds of scenarios and also for the Secure Act in general. Now, minor children and planning scenarios. So minor children are eligible designated beneficiaries, but as I mentioned a few minutes ago, there could be some scenarios where this is not really either important or it's not going to be something that's that viable to worry about. We talked about the fact that when a child becomes of the age of majority, they are now no longer eligible designated beneficiaries. They are just simply designated beneficiaries, and they have 10 years. So in that scenario where a parent dies and leaves an IRA to a child who's an eligible designated beneficiary, but now the child turns 18, they are now going to have 10 years to deplete the IRA, whether it's individually to them or in a trust. We talked a few minutes ago about whether to use a conduit trust where distributions would actually be distributed out to a child who's a minor. And we normally would not do that. We normally would not even consider doing something like that because that would create a guardianship situation for a minor child. The court is involved. The child gets the money in the guardianship when they're 18. We normally would not do anything like that. But with today's world and the Secure Act, we may not have any choice except to leave an IRA to a young child or a group of young children in a conduit trust on the notion that even though they're going to receive distributions, that those distributions are not really going to accumulate outside the trust and cause a guardianship situation, but will be used pretty quickly by the parent or guardian to buy things for the child that the child may need. So outright distribution is actually a possibility here. It doesn't seem to be very viable, but outright distribution could be a scenario depending on the age of the children. And then, of course, we have issues, as I mentioned earlier, where there are common trusts with multiple children. maybe one of those children is an eligible designated beneficiary because of special needs or other issues, and of course separate trusts for children, and all kinds of scenarios in planning for minor children. So I would characterize planning for minor children, and of course this is going to be for younger clients that have minor children, although that's not always true. I would say that this kind of planning is really planning for I guess the lesser of all evils. So I don't think there's any really good planning that can be done for minor children. There's no perfect planning that can be done for them. It's in the context of the Secure Act, it's more or less making sure that we're the least problematic solution is what we're trying to measure, and measure that not only on our own, but in consultation, of course, with the clients and the size of their assets and that entire situation. Now, disabled persons and chronically ill persons are eligible designated beneficiaries under the Secure Act. We know that. We're very happy about that. We're happy that this exception was carved out. So a disabled person 9 times out of 10, or maybe even 10 times out of 10 in some cases, would never be an outright beneficiary of a retirement asset. But their trust, because the trust has got to be only for the benefit of that disabled person, their trust also qualifies as an eligible designated beneficiary. So we as attorneys, we have to make sure the trust qualifies under the rules, or the disabled person or the chronically ill person who was subject to the new rules favorably for themselves, lifetime treatment for themselves, now they will be subject to the worst of all, the 5-year rule. So we don't want the trust for a disabled or chronically ill person to fail. Now, not all special needs families or families with disabled people involved or beneficiaries that have chronic illnesses, not all families are going to use an accumulation trust. There are wealthy families, of course. Many of you are aware there are wealthy families with children with special needs. Those families may choose that they don't have any intention of the child qualifying for means tested benefits. So therefore, they would not necessarily use the supplemental needs trust that we traditionally use, that preserves the benefits and maximizes the lifestyle of the child with regard to public benefits. And the supplemental needs trust is a separate world of support that's been created. So many wealthy families should be given the option to think in terms of a conduit trust. And we typically, again, would not think in terms of a trust that passes out distribution to a person with disabilities. But there are going to be many examples in today's world, especially today, where there are wealthier families with special needs children, and those children with disabilities are not ever going to qualify for means tested benefits, and they don't necessarily have to have a supplemental needs trust. So if we are designating an IRA to a conduit trust, again, we're not really planning for eligible designated beneficiary status, but we are going to be able to preserve the intention of the grantors by not tying up those assets in a supplemental needs trust. So that is just something we all need to be aware of. Now, getting to the next bullet point, which I will call the routine or more prototypical planning scenario for families of modest wealth or even significant wealth. This is the third-party supplemental needs trust, and this is the trust that is typically the bread and butter of special needs planning. It qualifies as an eligible designated beneficiary. And remember that, as I mentioned, the trust qualifies even though it's a trust. It qualifies because the trust is really giving the sole beneficiary treatment to the beneficiary who has the person with special needs. And this is typically drafted as an accumulation trust. We have to be very careful because even though the IRS exempts this disabled or chronically ill person from the Secure Act, even though they get this wonderful new class treatment that they can stretch out the benefits for their lifetime, the drafting has to be such that it doesn't mess that up. And the reason I'm saying that is the accumulation trust rules have not changed. And for those of you who are not familiar with this, the accumulation trust, Uncle Sam does not like that, as I've told you, because Uncle Sam is asking this question: when will one of the subsequent beneficiaries get outright distribution? When will someone down the line get distribution outright so that we can tax that money? So with an accumulation trust, we have to be careful that we don't cause the 5-year treatment, that we make sure we jump through the hoops Uncle Sam has set forth for an accumulation trust. And that takes a little bit of consideration. There are some pretty simple solutions to that problem to make sure that the drafting doesn't mess up the accumulation trust, or excuse me, the eligible designated beneficiary status. But we won't have time to get into those today. But just know that attorneys still have to make sure that even though the disabled beneficiary is exempt from the Secure Act, we still have to make sure that the trust jumps through the hoops that Uncle Sam has set forth for accumulation trusts. That gets to my next point, and I'll just say one of the simple solutions is in the special needs trust, if after the person's death who has special needs, if that person passes away, if their IRA assets will go outright to a contingent beneficiary, to the next beneficiary, then that will satisfy a lot of what we are concerned about. So that is one of the simple ways of dealing with Uncle Sam's rules. The problem is many parents don't want that money to go outright after the disabled person's death. They want it to continue in further trust. And that can be done, but that is a morass, and it's possible that the drafting will fail. So outright distribution after the disabled person has used the IRA money during their lifetime, that is one of the surefire ways of dealing with Uncle Sam's rules. So we want to optimize the supplemental needs trust for retirement plans and avoid the risk of the 5-year rule. Persons who are less than 10 years younger. So these are parents or other older relatives, or it could be siblings and friends and other younger beneficiaries. So a trust for any person under this category must be a conduit trust for this person to still be considered an eligible designated beneficiary. An accumulation trust will not qualify for an eligible designated beneficiary status. And again, what are we talking about? We're talking about persons who are less than 10 years younger having the right to stretch out IRAs for their lifetime as if we were still under the old rules. So this is a pretty significant thing, but a trust could be used for one of these people. It just must be a conduit trust. Now, we can't forget persons who are more than 10 years younger. Now, these people are not eligible designated beneficiaries. These people are just designated beneficiaries. Outright distribution, we talked about this early on. This guarantees the 10-year payout, very safe. Conduit trust guarantees the 10-year payout. So I hope you're seeing a consistent pattern here that where the conduit trust is used, Uncle Sam is fine with that because they know that distributions are going to come out to the beneficiary and they will be taxed when they are made. A non-conduit trust, but is a see-through trust. This is a trust that qualifies under state law. The documents are distributed to the custodian by October of the year following death, and there's 2 or 3 other requirements of the see-through trust. This will qualify for the 10-year payout as well, but it is not tax favorable. And of course, a non-conduit trust, which is also a non-see-through trust, we certainly don't want that. That's going to get 5-year treatment. Now, a few more examples. Payout after the death of a designated beneficiary. So I want to focus your minds here right at the end of the presentation. We've had a designated beneficiary. That person gets 10 years, right? So what happens after that person's death for the succeeding beneficiary? Well, right now, under the rules, the balance of the 10 years or whatever's left is what the succeeding beneficiary gets for a designated or non-designated beneficiary. So they get to use the balance. This is the person who had 10 years. That person dies. Now there's a balance of the 10 years left. The IRA has to come out in that balance period. All right, I know that was a lot of talking. That was a lot of dense material. That was a lot of some things that you already know, probably some things you didn't know. I hope you were able to take away some nuggets of information that you can use this week, next week, and in the months ahead. I'm going to strongly recommend that we work as an advisory team, that we work in a collaborative fashion, that we continue to try to perfect that in our individual relationships. Whatever those relationships are, we should be trying to figure out what are the steps we have to take to work collaboratively for the benefit of clients at the highest levels. We want to review clients' estate plans in light of the Secure Act for any needed changes. And again, collaboratively hold joint meetings to explore and define the issues for particular client situations. This is not easy to do in reality, but we want to make time to do that and shoot for or strive for that particular type of practice together. And we want to provide clients with viable action plans because that's what they're looking for. And I'm feeling as time goes by, they're starting to get the realization. Clients are realizing this is a very serious thing as we continue to accumulate unprecedented amount of retirement assets. This is a very, very serious thing that we need to make some decisions about and ongoing decisions. So I'm going to stop there and thank you again for your time and attention. I'm looking at my watch and I guess we are about 2 or 3 minutes ahead of time, not quite as ahead as I thought we were, but in plenty of time for any further questions or answers. Again, we want to be a resource to you. We want our facility to be a resource to you and work together and to reacquaint ourselves together after this COVID period that we've been working through and continue to work through. Jeff, I'm going to turn it back over to you.
All right, Steve. Well, thank you very much. As always, really excellent presentation. And we do have some questions here to pose to you, a few here, I think. So we'll start from the beginning. What better place to start? So the question is, we have here, if I have a TSP, is it better to draw out and put in a Roth or a traditional IRA, or what other safer place to put the money? Should we do that now or when we reach minimum distribution age?
Thank you for that question. So I'm going to say that no matter what I would respond to that question, I wouldn't be qualified to answer that question because I don't know enough about you and I'm not a financial advisor. So what I would recommend just as a threshold of response is that you either talk to me after this and I will help us work together with a financial advisor or your financial advisor to get an answer to that question. My initial reaction is that perhaps you're going to want to roll over that TSP to an IRA where you may have more choices and you have some options that you may not be thinking about right now, and that we explore the answer to that question collaboratively with your CPA, with your financial advisor, and with my input on this end as an attorney. But that's an excellent question that I think needs the involvement of a financial advisor and a CPA.
Okay, thank you, Steve. Before I get to the next question, of course, now would be the time to get those final questions into me at your earliest convenience. Thank you very much for that. Next question is, are 2 separate special needs trusts needed if retirement assets are going to be distributed?
Yes, so my assumption from your question is that you may have 2 children who each have special needs and require a supplemental needs trust. And the answer, in my opinion, in Maryland would be yes, because just the way the law is structured in Maryland, and I think it would be in the highest and best interest of both of those children if there were 2 separate special needs trusts.
Okay, thank you. This is a bit of a long one, so listen intently. If I leave my retirement assets directly to my permanently disabled son, he would qualify for the exemption, but would lose entitlement to public benefits. On the other hand, I had read that if I leave those assets to a special needs trust for him, he'll be able to keep his benefits, but will effectively lose the exemption and the ability to stretch out the special needs trust withdrawals. Not correct?
Thank you for that. The answer to that is a great question. The answer is that is correct. It's not correct. What you had heard there is not correct. So if your child's special needs trust is properly drafted, and what I'm referring to here is what I would normally call, as part of your estate planning, a third-party supplemental needs trust. This is what I would refer to as the bread and butter special needs trust for parents that are leaving assets to their children. And the answer is, if this trust is drafted right, not only is your child an eligible designated beneficiary, but there's a special carve out in the IRS rules, even at this early date, that the supplemental needs trust or special needs trust is carved out as well. And it is an eligible designated beneficiary. And if that special needs trust is properly drafted, your child, when you leave those retirement assets straight to that trust, now this is an IRA I'm talking about here. When you leave an IRA straight to that trust, your child will qualify for lifetime treatment as far as minimum distributions, just as if you would have left it to your child outright.
Okay, very good. Thank you. So those are all the questions we have for now. Again, any last minute ones, please get them in to me now. And it looks like somebody actually did. So let me go ahead and pull that up. And it's from our friend Kelly. Hi, Kelly. How are you today? So we have a comment on the TSP question. Maryland tax law can have an effect. IRA distributions do not qualify for the Maryland pension exclusion, whereas TSP does. So that's his comment, Steve.
Oh, thank you. Thank you, Kelly. And anything that you want to elaborate about that further, if you'll send it to Jeff, we'll be glad to send it to all the attendees.
Yes, absolutely. Thank you very much, Kelly. Okay, so those are all the questions and comments for now. I'm going to give just 1 minute ending here. So if you do have any last minute questions, please go ahead and get those in. Go ahead and put myself on camera here. So thank you again for attending. We always appreciate you being here for our advisors forum, which we try to hold every couple of months, and we will have one in October, probably the end of October. So we look forward to having you then. I'll be sending out the video for today, probably late today or first thing tomorrow morning. And we do have a couple of events I'd like to mention to you. On September 15th, we'll have a new presentation, Achieving Perfection for Your Legacy, Intentionalism and Estate Planning. This is a presentation that is very near and dear to Steve. It's a subject of a book that he is working on and a topic that he has put together with a lot of work and effort, and we're really looking forward to that on September 15th. And on September 21st, we are going to be starting our wellness series as part of the Elville webinar series with two nationally renowned speakers, Dr. Michelle Fritsch of Retirement Wellness and Miss Ellen Platt of the Option Group. She is an aging life care manager. Both are presented as part of our series and are outstanding speakers. I can't wait to see both of them in person working together and presenting together. It's going to be outstanding. So we already have a great crowd for that, and it's just going to keep going up over the next month or so. So that's September 21st, and it's Wellness During Uncertainty. And there is certainly a lot of uncertainty out there right now. So how can we maintain our wellness during these challenging times that some of us are facing? So those are a couple that we have coming up. We do have a couple more later in September packed in there on the 24th and 29th with Steve. One is our estate planning essentials on the 24th, and on the 29th, we have a new topic, legacy and charitable giving with Steve as well. So looking forward to that for September, and we'll probably get another couple in there as well. So check out our website, elvilleassociates.com/events if you want to register. And as always, we'll have some invitations coming out as well. So let me check to see if we have any other questions. Many thanks for a great presentation, Steve.
Thank you. Thank you.
Kelly said you answered that question perfectly, Steve, just as an aside. Oh, let's see here. Okay, we have one more request, Steve. Please explain it says see-through trust in more detail if you have time.
Yes, just very briefly. So the IRS says that if a participant leaves a beneficiary designated asset like an IRA to a revocable trust. Now I'm talking about looking at the revocable trust like a funnel, and imagine that IRA is beneficiary designated straight to that trust. The trust is either going to qualify as a see-through trust, and what that means is the IRA will be treated as if it went through the trust. It went through the trust straight to the beneficiaries as if the trust did not exist. As if the trust did not exist, as if it were just left straight to the beneficiaries. That's called a see-through trust, and there are about 3 or 5 requirements for that. And one of them is that the plan documents get delivered to the custodian on time in the year following death, that the trust qualifies as a valid trust under state law. And I apologize, I don't have the other 2 or 3 bullet points in front of me, but these are very simple requirements. And if the trust qualifies as a see-through trust, then the IRA is not considered to implode as it comes through. Now, just a real quick example, let's say that there was a charitable distribution in that trust. Let's pretend we had 2 or 3 beneficiaries that are the residuary beneficiaries of the trust, but prior to the distribution to those beneficiaries, there was a $50,000 bequest to a charity. So when that IRA comes through that trust, it hits that charitable designation or that charitable bequest, and that's going to be something that will cause the trust to fail as a see-through trust. And what will happen under the old rules is that IRA will now implode, and instead of lifetime treatment for the beneficiaries and under the old rules, now it has to be distributed in 5 years. Now, there are ways of dealing with that, and IRA beneficiaries become final, believe it or not, on September 30th of the year following death. So as long as that charity, in my example, was satisfied and that $50,000 was distributed to that charity prior to September of the year following death, September 30th, now we've taken that problem out and the trust will qualify as a see-through trust. So see-through status is important. And it was more important, let's say, arguably, prior to these Secure Act rules, but that is the definition of a see-through trust. It's a trust that qualifies under those 5 criteria, and making sure that nothing causes an implosion as the IRA goes through the trust is one of the things that has to be avoided to make sure that we have see-through trust status.
Okay, thank you. Do it one more. And that question is, would the choice of remainder beneficiaries of a special needs trust, individuals versus charities, affect the exemption?
Yes, thank you for that wonderful question. The answer, in my opinion, is yes. If someone says, and I just had this question recently from a very dear client, if someone says, well, you know, we want this IRA money to go into a supplemental needs trust, and then after my child's passing, I want the money to go to charity, that is going to cause a problem there where we're not going to have eligible designated beneficiary status, because that's the same kind of problem. It's going to go in a way to a non-exempt beneficiary that's going to cause eligible designated beneficiary status to go away. So we don't, unfortunately, we can't do that with IRA money. Now, what could be done is that non-IRA money could go to the charitable beneficiary and not the IRA money. So that can be bifurcated in the document to make it very clear so that you don't have that ineligibility problem.
Okay, great. All right, I think that about does it. Thank you so much for being here today. We appreciate your support and for your relationship with Elville & Associates, and we look forward to getting together with many of you soon. So have a great rest of your Wednesday, and thank you for your support of the Elville webinar series and our advisors forum. Have a great day, everybody.